Please, Lordship. Lordship, I beg to make a mention for item 5, Lordship. Lordship, this new council is having some difficulties, so I pray the matter may come on Thursday, Lordship. You have informed the other side, Your Lordship.
This is number 5.
Yes,
It's
Lordship.
a long pending matter.
Yes, Lordship. The senior counsel is having difficulties, Lordship. So, fix and prepare matter on Thursday, Lordship.
On pre-made by the petitioner, this is matter to 1 week.
5, 6, 7, and 8, Lordship. It's similar. Leo Pledge.
May we please, Your Lordship?
Yes.
Your Lordship, I beg to make a mention for item number 19. Your Lordship, the senior conducting counsel is still in discourse. I beg 3 weeks' time, Your Lordship.
19.
19, item number 19.
Your Lordship, I am for respondent number 3 and 4.
Any objection?
I beg.
Any objection?
No objection.
Prayer has been made on behalf of the learned senior counsel who is conducting the case, seeking accommodation on the ground of personal difficulty of the said senior counsel. The matter not being objected to by the respondent, prayer is allowed. This is matter up to 3 weeks.
Highly obliged, Your Lordship.
How is he, Mr. No?
Still has to undergo
Is
treatment, Your Lordship.
is he bedridden or is he
Actually,
hospitalized?
ulcer diabetes has developed, Your Lordship, so he still has to undergo treatment. Highly obliged, Your Lordship.
May it please, Your Lordship, I beg to mention item number 14.
It's an old
Yeah,
matter.
Mr. GM, thank you. He was on his way back from Agrod and unfortunately his car broke down at Umjaran, so if we can adjourn the matter for the day.
Who's for the respondent?
I'm for the respondent, District Council, my lord.
Lordship, I'm for respondent number 4.
On pre-made by the petitioner, this is matter tomorrow.
Let it be after a week, my lord. Tomorrow again it will be the supplementary list. It will not, may not reach also, my lord. Because we was ready, my lord, today. And this matter has been repeatedly adjourned from one side only, my lord. My lord, if my lord see the order sheet, it will reveal that from one side it has been adjourned for one pretext or the other. Let it come after a week, my lord.
This is matter of the week.
Highly blessed, my lord.
Lordship, item number 16 as well.
Lord, item 16 has been argued by Mr. Paul also, by me also. It was only for the private respondent, my lord. That matter was argued.
Who's the
that was
that
appointment in
that disability matter?
disability, my lord. That has been
Even I think the private respondent also has considered.
yes,
In fact, he is the one who is getting the benefit. And the only challenge would be on that list.
yes.
Vacancies of 32, list of 54 being brought out.
No, that is in this issue, my lord. The candidate petitioner was not eligible. He was not having the basic eligibility qualification. He was not having 50% marks, which is the basic requirement. His case was that this post is reserved for the person who is disabled, who is challenged, my lord, and therefore the private respondent should not have been appointed as a stopgap arrangement, because 60 days appointment was being done as a stopgap arrangement. So now in the meantime, my lord, because the petitioner is not entitled to relief, because if the writ is allowed also, the stopgap arrangement will go, and a stopgap arrangement will go. We have to do the recruitment, my lord. Now recruitment has been halted on these accounts. So if we remove that teacher also, there will be no teacher left for teaching now, because petitioner in any case is not. Petitioner has already given up the relief. So we have all argued the matter, my lord. Item 6.
But yes, what
These
is
were the
left?
instructions, Lordship, to seek time. Yes, Mr. Jem, thank you, was unable to be here today.
His car broke down.
Yes.
On pre-made by petitioner, this is matter to 1 week.
May it please, Your Lordship. Lordship, I beg to make a mention item number 10, Your Lordship.
2014 matter.
Lordship, Mr. Paul is out of station, Your Lordship.
This is that subsidy thing.
They already argued the matter, but
Then what is left?
they wanted some time for clarifications.
On pre-made by petitioner, this is matter up to 1 week.
Similar prayer for item 12, Your Lordship.
Not item number 18, my lord. This is archery matter, my lord.
12? Yes. 12. He's mentioning 12.
18, my lord.
12.
18.
You said 12 or?
Yeah, 12, Your Lordship.
You said 18, he said. He's making the mention, not you. Same. This is also an old matter.
Lordship.
This is those home guard matter.
Home guard,
You have argued the matter, isn't it?
Yes, Your Lordship, but Lordship, this matter have directed us to file an affidavit bringing on record. As on the last occasion, Lordship, we have established communication. But after sometimes we tried to call them also, Lordship, we could not establish communication, Lordship. So, Lordship, 1 more week, Lordship.
On pre-made by the petitioner, this is matter up to 1 week.
Can you oblige, Lordship?
Yes, you were saying?
18, my lord. Number 18. Mr. Sen is on the other side, my lord.
My lord, he has joined through VC, Mr. Senior GA.
Yes, so
This matter I'm praying for up to 2 weeks, my lord.
is this Mr. Sen or rather Dr. Musika? This is that matter where you said there's some talk or some
My lord.
discussion.
Basically, that's the ground I'm praying
What are
for.
your instructions here? Mr. Sen?
I don't have any official instructions on settlement as yet. If this matter can come up next week, I'll obtain instructions on it.
Yeah, up to 2 weeks, my lord.
Because this is connected with the other
Connected
matter.
with that, my lord. If it is settlement, all the
This
matters
is
will
with
be-
regard to the license.
license of the counter license, my lord.
Yes.
Your Lordship, were the interveners in this case?
Oh, you
This
didn't.
case has been filed, my lord.
So once the main matter is settled, I think your
first
concern will
challenge-
also be addressed.
Also, the question of maintainability has been raised by us, my lord. So that can be seen. Well, for the time being, if 2 weeks time is granted, my lord, I'll have instruction if settlement is really going to work or not, my lord.
Yes, Mr. Sen?
So no objection.
On prayer made by the learned senior counsel appearing for the Dr. N. Musika, appearing for the respondent. Matter is adjourned, not being objected to by the petitioner. List the same after 2 weeks.
Hello.
Obliged.
My lord, that item number 11, my lord. That's Hyderabad. The judgment
Yes.
has been passed, my lord.
So, what is the
The Andhra Pradesh High Court has disposed of the matter, my lord.
So we will proceed with the matter, my lord.
I'm giving a copy to my friend. He is not aware about this order, my lord.
you're not aware? Have you read the order?
No, my lord. I will.
What is the import of the order?
But this is a direct bearing on this matter, my lord. But this is the Assam Rifle personnel, my lord. He applied on deputation for National Police Academy in Hyderabad, my lord. And after deputation period was over, instead of reporting back to Assam Rifle, my lord, he wrote to, because he was from Andhra Pradesh, he wanted to stay in the Police Academy in Hyderabad, my lord. And he did not join after completion of the deputation period, nor he was granted extension by the Police Academy, my lord.
Okay.
So this created a situation. Then he approached the Andhra Pradesh High Court, my lord. The learned single judge gave him relief that allowing him to belatedly report back to Assam Rifles, my lord.
Okay.
Against that, we filed an appeal. Now, in appeal, the division bench, Justice Ujjwal Bhuya, my lord, the very recent order, said that learned single judge could not have passed such an order. Once he defaulted in joining, he should face the consequence of that. So, it is a direct bearing on this matter, my lord. You can have instructions on this matter.
We will have an instruction, my lord.
So 1 week? On prayer made by the petitioner, this is matter to 1 week.
May I please
Please, Your Lordship. Your Lordship, I beg to mention item number 15. I'm praying for 2 weeks' time, Your Lordship.
You're for?
Petitioner. I'm for the respondent 425, Your Lordship.
For the rest of remaining respondent, I'm appearing, my lord.
One week.
Okay, Your Lordship.
On premier by petitioner, this is met after 1 week.
Please, Your Lordship, I beg to mention item number 4. Lordship, the learned counsel for the petitioner, Mr. S.A. Sheikh, is currently out of station. Lordship, therefore, I pray for 1 week.
On premier by the petitioner, this is met after 1 week.
Highly obliged.
May it please Your Lordship, I beg to mention item number 17, my lord. I'm appearing on behalf of the petitioner, my lord. As the conducting counsel, Mr. P. Nongbre is currently out of station, my lord.
Who's for the respondent?
We are for the respondent, Your Honor.
Any objection?
No.
Prayer has been made on behalf of the petitioner, seeking accommodation on the ground of the learned counsel being indisposed. The prayer not being objected to by the respondent, same is allowed. List this matter after 2 weeks.
Humble prayer to allow me to move to unlisted motion tomorrow, Your Lordship. Some urgency is there, Your Lordship.
What is the matter?
This is the petitioner has not received a terminal benefit for the last 3 years, Your Lordship.
And what's the urgency there?
For the last 3 years, she has not received any terminal benefits, Your Lordship. The DCRG, despite being sanctioned, Your Lordship.
No, that will be, it will be heard in due course. There's no urgency in it. She has not been receiving for the last 3 years.
Yes,
so
Your Lordship.
you can't expect it to receive it within the next 1 week.
So my humble prayer, Your Lordship, can be taken the matter in motion tomorrow, Your Lordship, or any.
Yes, let it come.
Yes, Your Lordship.
Let it come.
Okay, Lordship.
Lord, item 13. On behalf of the state, I'm praying for some time. Item 13. Mr. Hazarika is not available.
You are for?
I am for the state on behalf of because Hazarika is the conducting counsel.
Who's for the petitioner?
I'm appearing for petitioner.
What is this matter about?
This is acquisition of land, my lord, without any authority.
They are claiming that there is an acquisition, but as per the report, my lord, there was an order of this honourable court for conducting an inquiry by the district council, my lord, whether the land was acquired or not. The case of the petitioner is the land has been acquired, my lord. But our case is there was no land acquired, my lord. It was only the expansion of the road, and that was already paid previously, my lord. They have occupied the land, and now they are claiming compensation, my lord. But as per the report, my lord, there was no land acquisition. It was only the expansion, my lord, of the road.
But that is not the actual situation, my lord. It will come
The
at
report
the
will
time of
reveal,
hearing, my lord.
Because the report, my lord, which has been prepared by the district council revenue officer, my lord, and even the petitioner was also present, my lord. They cannot show which one was their land, my lord.
So 1 week on prayer made by the state respondent on ground of personal difficulty of the learned GA. The same not be objected to by the petitioner. Matter is adjourned. List is after 1 week.
Obliged.
Daily costless, item number 1.
Yes, what is this matter about?
Lordship, this application is filed by the petitioner. Your Lordship, on 7/7/2022, a written FIR was filed by respondent number 2 against the petitioner, alleging that herself and her son-in-law, who is the VC secretary, has been alleged and threatened by petitioner 1, 2, and 3, and petitioner 4 son. Two sons have alleged alleged them and wrongfully restrained. On this incident, the petitioner the respondent 2 have filed an FIR, which has been registered as High Litigant PH case number 7 to 2022 under section 341-506-34 of IPC dated 7/07/2022. Here, Your Lordship, on completion of the investigation, it was found that the two sons of the petitioner was not involved in this case, as there was no evidence against them. Your Honor, Your Lordship, I would like to bring the brief fact of the case which I have mentioned in para 9 of my petition. Your Honor, here the actual case is that the petitioner 1 had filed RTI application against the VC secretary, who is the son-in-law of respondent number 2. And on this, in the marketplace, the respondent 2 son-in-law have alleged the petitioner 1. And Your Honor, on being the petitioner 1 was alleged by the secretary of VC, who is the son-in-law of respondent 2, along with his man. And petitioner 2 and 3, being the brother of petitioner 1, they have just come there to stop the argument between them, as they were threatening him to, and they were trying to assault him. And while the respondent son-in-law, while proceeding towards his home, he met the petitioner number 4, and he assaulted him, and he said that he will threaten his son, both the son, the elder son and the younger son. While the younger son, who is advocate, have helped the petitioner number 1 in drafting the RTI application. Your Honor, in this incident, petitioner number 4 has also filed an FIR against the son-in-law of respondent number 2. And Your Honor, the FIR has been registered in High Litigant PH. It has been registered as PS case number 6/7 of 2022 under section 506 and 352 IPC. Your Honor, the copy of intimidation letter is also enclosed here. Your Honor, I would like to bring here, as all the petitioner out here, they are belonging from the respective family, very respective family. And they have been staying in this Sabrabari village for decades, and they have no criminal record, Your Honor. And moreover, Your Honor, this section are compoundable. And Your Honor, moreover, if we see this respondent number 4, who is 62 years old, cannot restrain the respondent number 2 son-in-law, who is the influential person, Your Honor. And moreover, Your Honor, the case which has been registered against this petitioner has been laying there in the court of Dadangiri Court before the first class magistrate, and it has been 7 months, Your Honor. It is fixed for copies. And Honor, this FIR has been falsely implicated, as in the FIR I have annexure in annexure 1, it is clearly written that the son of the petitioner number 4 has threatened, and the younger son has contacted the respondent 2 son-in-law through phone and threatened him with their consequences, but there was no evidence against them. Your Honor, this FIR is falsely implicated against the petitioner. So Your Honor, my Lordship, my prayer is that Your Honor kindly allowed us for quashing the FIR, Lordship.
Have you issued notice on the respondent?
No, my lord. Today is the first day of motion, it seems. So notice will have to go to respondent number 2, my lord.
So you
and
are,
in the meantime,
will be responsible.
I'll be appearing for respondent number 1, my lord. For respondent number 2, they will have to take steps.
Yes, Lord.
And in the meantime, my lord, I believe if it does not hamper the lower court proceedings, my lord, we should be also getting the next date, so that we can, otherwise we can call for the records also to see what is the progress of the case.
As has been submitted, the matter is only at the stage of copies.
Your
Copies.
It has been
which has not been supplied.
So, my lord, if I may submit, my lord, let the lower court's records be called. We can examine here and we can make
Not
some.
necessary, not necessary. What you can do, Mr.
My
Sengupta,
lord, I'll call a status report from
call
my
a
IO.
status report and a copy of the CD.
Case diary and charge sheet.
Just get that.
Whatever evidence is there, we'll bring it in.
Good enough, just for the perusal of this court.
Of this court, yes, my lord. I'll do so.
But Miss Learned Counsel for the petitioners, Mr. S. Sengupta, Learned Additional PP has accepted notice on behalf of respondent number 1.
1.
As prayed for, let notice be issued upon the respondent number 2, returnable within 2 weeks. In the meantime, the learned additional PP has submitted that he may be allowed to produce copies of the
charge sheet,
latest status report of the case, including the copies of the CDs. This is matter after 2 weeks.
Obliged, my lord.
Item number 2.
Your Lordship, is a part heard matter, Your Lordship. Your Lordship, I'll seek 1 week's time as my senior is indisposed today, Your Lordship.
I think only authorities are to be.
Guwahati or here, my lord.
Yeah, no, but only I think. Is it only for authorities or?
He needs to give some submission.
Oh, that. Okay. On pre-made by the petitioner, this is matter up to 1 week.
Item number 3.
fact, Your Lordship, item number 9 is connected with 5 to 8, Your Lordship. The same has been adjourned, Your Lordship.
They have sought adjournment again. That's a Nehu, Nehu matter, my lord.
Oh yes, but
Yes, yes.
this is all interconnected.
Yes, my lord, my lord.
So same order, Mr.
My lord.
Same order as in Tuma. Item number
5 to 8.
5 to 8.
How do you allow it?
Item number 20.
What is required here? What is required?
So hearing.
I thought we have only
Notice was issued on the last day.
Okay.
Only that.
Yes,
only
Mr.
that
Karolang,
legal-
you are ready?
Only that law point is
Yes,
is
yes.
involved.
Whether you see,
there is no dispute on facts.
Facts, yes, no dispute. Whether the provision of the BSF Act would have a precedence over-
Even that is settled, my lord. In fact, a very recent decision, I was just going through 2022, my lord. Justice Chandrachud's a very detailed order from Sikkim High Court, my lord.
Okay.
And he has dealt with almost every single aspect of course, that was vis-a-vis Army Act, but the provisions are perimetry, my lord. The same provisions are there under the Army Act, which are there in the BSF Act and CRPF, and other acts also, my lord. The only question, my lord, now this on in this particular decision, it has been clearly held, my lord, in case of any army or paramilitary forces, the ultimate decision. Now they have categorized the offences into 3 categories, my lord. In one category, BSF will have exclusive jurisdiction, BSF court. In one category of offences, they will not have jurisdiction, and third category is where they both have normal regular courts, and BSF court will have concurrent jurisdiction. So, and that has been dealt with that.
That is based on the severity of the offence or on what?
But the offences are categorized in the act itself, my lord. Because for an offence, my lord, a BSF personnel, for example, on his leave period or when he is not on duty, he commits a theft, my lord. So he cannot be tried under BSF.
Sit down. Why is that? Sit down.
So there is no dispute with regard to that, my lord. Here the only question now is pending investigation, my lord. Now law is also settled. I'll point out those paragraphs, my lord, that once charge sheet is filed by police, my lord, then the discretion is solely with the commandant of BSF whether to claim that case or allow the normal court to proceed with the trial, my lord. Now here, in exercise of that power, BSF has already taken a decision. Now that decision will be exercised, we will file an application as soon as a charge sheet is filed in the criminal court, my lord. So, my lord, what is clear, my lord, the police has power to investigate, my lord, and even to file a charge sheet. But before cognizance is taken by the CJM or whichever court is the competent court, my lord, they have to issue a notice to the commandant that this appears to be the offence committed in the course of duty, my lord, course of active duty, and whether BSF will claim the trial or the session court will try the matter. Once that notice is received, then commandant files an application enclosing the copy of decision, section 80 decision, and then the trial court is bound. I'll point out those provisions and in conjunction with the findings of the Supreme Court, my lord. So even that is clear, my lord. Once a charge sheet is filed, that is one stage. Before cognizance is taken, there are certain procedure prescribed. Then ultimately, if magistrate agrees with the commandant, my lord, then there is no dispute. If magistrate does not agree with the commandant, then the matter is to be referred to central government, my lord.
Yes.
Central government decision is final decision. But that stage will come only after charge sheet is filed, and the stage of section 80 comes. Section 80 and 81 will come into picture only after charge sheet is filed, my lord. Here we have no issues with as far as investigation is concerned. The problem only we have, my lord, at this stage is whether custody can be given, and because the moment we hand over the custody, he will be arrested by police, my lord. We have no problem to that extent also, my lord. But the difficulty lies, my lord, in view of the Supreme Court decisions, which say that if a custody is handed over to normal police, that amounts to that will stop us, estoppel by conduct. That is what the Supreme Court has held. That will amount to surrendering to the jurisdiction of regular courts, and in such cases, then BSF court will not have any jurisdiction after that. I'll just point out those few paragraphs. Para 31, my lord.
This is the latest.
No, my lord. The latest one I have referred to this, my lord. I'll place that also, my lord. There is some. I'll just leave that. Or para 31, my lord.
Yes.
From these circumstances, in our opinion, it is legitimate to hold that the competent authority had handed over the appellant to the civil authorities for being tried after the former had considered the question of so handing him over after consultation with the headquarters. In the circumstances, it follows that the designated officer under section 125, that is equal to section 80 of the BSF Act, who had the discretion in the first instance to decide that the appellant should be tried before a court-martial, had decided to the contrary. Surrender of the accused to the civil authorities to be dealt with by the latter after being made aware of the nature of the offences against the appellant. It is clear indication that the decision of the military authority was that the appellant need not be tried by a court-martial and that his trial can take place before the criminal court. And these circumstances, there was no occasion to follow the procedure under section 126 or rule 4, as the military authorities have made abundantly clear that the appellant need not be tried by the court-martial. So, my lord, here this Honorable Supreme Court, because in the similar facts, my lord, the army authorities handed over the custody to the civil police, my lord. Then Supreme Court said once you do that, you cannot claim that amount to surrendering your jurisdiction. But the similar point has been, in fact, this decision has been referred to in this later decision, my lord, 2022.
What's the citation?
Well, this is 2022, Volume 7, SCC. Wait.
Yes.
Para 51, my lord.
51.
51, my lord. Third last page.
Yes.
The entire sequence of events, both before and after the completion of the investigation, provides a clear indicator that the commanding officer took a conscious decision that the investigation trial should be conducted in accordance with the provisions of CRPC. In the earlier parts of this judgment, we have narrated these circumstances, namely the handing over of the accused by the army to the custody of the police, the cooperation of the commanding officer, Colonel R.R. Nair, in meeting the requisitions of the investigating officer, the recording of the statement of the informant under section 164 CRPC, the recording of the evidence of the commanding officer during the course of the criminal trial, thereby indicating a clear intent that the trial would proceed in terms of the jurisdiction of the ordinary criminal procedure court. The respondent accused had relied on the decision of this court in so and so towards the provision of section. This we can skip, my lord. So, my lord, here what has happened, my lord, here the learned court of session in the Sikkim case, my lord, after charge sheet was filed, directed that this particular case should be tried by the court martial, my lord. Against that, the revision went up to Supreme Court. Supreme Court held that by conduct, now army cannot claim this case because they handed over the custody of the accused. They allowed 164 statement of accused to be recorded by. They participated in the trial. They went as a witnesses, my lord, and after that it was too late for them to claim. So by conduct, the army had surrendered the jurisdiction to regular court. So, my lord, we don't want to reach that stage. That is why we have come before this honorable court at this stage itself, because surrendering the accused will ultimately lead us to the same situation which I pointed out to two Supreme Court decisions, my lord. And that is the reason, my lord, why we have approached this honorable court, that this will lead us to surrendering jurisdiction, and that was the implication later on. And because the sole discretion to claim a case, my lord, as to take a decision who will try the case lies with the BSF authority in the first place, my lord.
If I can understand correctly, the decision that you have cited is the fact that the army, or let's put it,
BSF, my lord,
the army have surrendered their authority or jurisdiction to the civil courts,
my lord,
or rather to criminal courts,
my lord.
So in that case, what happened is they cannot revert back and claim jurisdiction.
Exactly, my lord. That is our whole case, my lord.
So where is perhaps the observation in these cases that ought not to be the situation? They have done it, but that ought not to have been done.
My lord, I'll take to the other paragraph. It's quite a long judgment, my lord, but it elaborates on all the aspects, my lord, this judgment. Well, para 49 and 50 will throw some light on this, my lord. My lord, then, my lord, over and above this, my lord, section 45 of the CRPC.
Let's talk about arrest.
Section 45, my lord.
They have already been arrested.
Well, he has been arrested by the force itself, my lord, not by police. Because we are not regulated by CRPC, my lord, as such. No member of the armed force of the Union shall be arrested for anything done or purported to be done by him in the discharge of the official duties, except after obtaining the consent of the central government. Yes, sir.
See, now you have to you have to distinguish between arrest and custody. Because arrest, as it is now, they are arrested. They are in your custody.
But he has been arrested. They are in our custody, my lord, because the arrest as defined under section in CRPC, my lord, the BSF Act may not use the word arrest, my lord. What is the word used in BSF Act?
See, Dr. Muziga, what you have to do is you have to convince this court, looking at the impugned order, as to how that order was passed without considering the relevant provision of law, whether BSF Act or the CRPC, and as to what is the preeminence of the BSF authority over the matter, so as to retain custody of those who have been arrested to that extent. Otherwise, if per se the magistrate has the jurisdiction to pass such an order, then nothing can be done.
And my humble submission, magistrate has the power to issue a warrant of arrest, my lord, if any application is filed. But this kind of order to hand over the custody, and that order also passed to BSF authorities. In my humble submission, there is no such provision in the entire CRPC, which the London magistrate could have exercised and passed an order. In my humble submission, if at all they required such kind of an order, they should have moved this honorable court maybe under 482 or 226.
It could not have been passed because of the provision of 45, section 45.
Section 45 read with section 81, my lord. Section 45 and 80 and 81 of BSF Act does not give magistrate any such power to direct BSF to hand over the custody, my lord. And this being an interlocutory order, my lord, an objection was raised that we should file a revision application. On the earlier occasion, I placed an order where the Supreme Court had this remanding. This is something in the remand, my lord. Is an interlocutory order, and a revision will not lie. against such an order. And in another decision of Madhu Lime, my lord, there's a famous decision, the Honorable Supreme Court has held that 482 can be exercised even in respect of interlocutory orders, though revision is not maintainable against that. So, in that view of the matter, my lord, in my humble submission, this Honorable Court has jurisdiction. This not being an this being an interlocutory order, 397 or 401 is not maintainable. Only remedy for us is to come under 482, my lord. As far as the maintainability aspect, my lord. Madhu Lime, if you lordship desires, I can put this and make a synopsis, a small synopsis also, my lord, of the relevant judgments.
You can do that, but we will have to hear Mr. Bhattacharjee now and see what he has to say. Because here is purely
para 10, I think, lots of
purely it's a question of
only question.
It's a legal.
There is no quarrel. There is no quarrel on proposition. I do not know. This basically is not required. I am not disputing that proposition. So far as the power of the court under 397 and 482 is concerned, I am not. I am definitely.
That is well settled.
No, I thought that was the objection taken on the first.
Well, the facts and circumstances of this case, my lord, this 482 application will not lie. And why it will not lie, my lord, I will just present.
Subject to what?
What is the paragraph relied upon in this Madhu Lime's case?
Para 10, my lord.
10. Yes.
Wait, please, your lordship. Now, my lord, just before coming to the proposition of law, my lord, just I would refresh the mind of this court so far as the factual aspect is concerned, my lord. Now, right from the impugn order, my lord. Now, impugn order, my lord, only the operative part. I am not bothering your lordship with this. This lordship at page 18, the last part.
Yes.
My lord, in view of the reply submitted by lordship.
Yes.
Down below. The Commandant, 4th Battalion BSF, dated 9/5/23, who has extended full cooperation into the matter, the court hereby directs the Commandant, 4th Battalion BSF, to hand over the accused persons, namely so-and-so, so-and-so, and so-and-so, to the IO for the purpose of investigation on 16/5/2023. Now, what I am trying to project here is that, my lord, the court has not passed any order of custody. It has neither directed detention of accused in police custody or in judicial custody. Now, it only speaks about the handing over of the accused for the purpose of interrogation, my lord. Now, whether a person should be detained in custody or not during the stage of investigation, that is a prerogative of the police, my lord. They might find that these people are innocent. They may not take them in custody. And, my lord, if they take them in custody, then for section 45(1) will come into play. Now, section 45(1), my lord, is not relatable to these present proceedings. What Union of India has to do with 45(1)? 45(1) guarantees protection to one particular individual, my lord, who is subject of armed force. 45(1) would definitely not give them any age so far as the trial of the case is concerned, my lord. My lord, should not be confused that way, my lord. Now, my lord, the magistrate's order, my lord, is not an interlocutory order, my lord. Why it is not an interlocutory order, my lord? Because it finally decides so far as the order of handing over is concerned. Because it's a clear-cut direction. Now, two aspects. If my learned friend says this is not a final order, then also he cannot come under 482. Now, its option is with them. If he says it is an interlocutory order, my lord, then I will say, my lord, it is open for him to go and approach the trial court. The bar under section 362 will not come. 362 CRPC will not come. 362 CRPC comes, my lord, when a final order is passed. So there is no question of finding, my lord, and invoking jurisdiction of inherent jurisdiction of this court under 482, my lord. The petition is not maintainable at all, my lord. Now, my lord, if lordship, my lord, at all entertains this petition at this stage, my lord, it will affect us also because we will be voting for him. If it happens like that, my lord, they approach the trial court seeking modification or alteration of this order. As my London phrase, that is interlocutory order, so this will be open for the court, my lord. Then if that order, my lord, assuming that is passed against us, then we will have a remedy for session court or before High Court. But then if right at this stage, if Honorable High Court exercises jurisdiction, my lord, we will be losing our forum, my lord. This cannot be, my lord. 482, it is not that my lord, it would be availed for each and every, my lord. Just because they are comfortable in High Court, they will come and avail 482. It cannot be, my lord. 482, my lord, definitely I can understand, my lord, it is invoked, my lord, when a person deserves relief. But then the connected provision, there is no, my lord, direct connected provision, my lord, which basically can be invoked for providing that relief, my lord. In such a case, 482 is invoked, my lord. But then otherwise, when remedy is available in law, my lord, 482 cannot be invoked to negate that particular provision of law, my lord. So either way, my lord. If he says that is an interlocutory order, my lord, he can go and approach the trial court, my lord. And if he says this is not an interlocutory order, my lord, then he can come by a way of revision. 482 is no answer, my lord, in both the situations. Now, this is the first, my lord, to my objection. Second thing, my lord, lordship may kindly come to the order passed by the Deputy Inspector General of BSF, my lord. My lord, lordship comes to page 25, my lord. It is annexure 4 to their writ petition.
Yes. Yes.
Lordship may kindly come to paragraph 3, my lord.
Yes.
As the offence is committed by so-and-so, number so-and-so and so-and-so of 4th Battalion BSF while discharging their bona fide government duties, therefore considering the fact and circumstances of the case, I, the undersigned, being a competent authority of Section 80 BSF Act 1968, decide that in case any charge sheet is filed, my lord, lordship will take one thing, I'm pausing for a moment. BSF Act Section 80 has been invoked at this stage, at the stage of investigation when there is no charge sheet in it, admittedly, my lord. Now, my lord, whether that can be invoked or not, my lord, that is also a subject matter of challenge, my lord. I'll be placing, my lord, because placing the rules also. Now, it cannot be, because by the very words which they have used in their communication, it says that the above person before the competent authority of trial, the case can be claimed from the criminal court for the trial, my lord. Now, is there any instance, my lord, they have ever claimed this case? If Section 80, my lord, empowers the concerned official of BSF to decide, my lord, whether it should be taken up by a security force court or by a normal court, and if has the power, my lord, to take over the criminal trial, then in such a case, my lord, there has to be an application filed. Now, that has not been done. That is not been done. The case of charge sheet has not come. Now, kindly, my lord, go through the entire BSF Act, my lord. The criminal case and the investigation, which manner it has been done and what is the procedure prescribed. Definitely my learned friend would be in better position to say it. But then for me, from the communication, I could make out, my lord, except for ordering in court of inquiry, nothing has been done. Now, what is court of inquiry, my lord? That also I will come to it, my lord. It is very limited, it is confined. It cannot, my lord. It's a kind of eyewash, my lord, just so that they can, just to project that they can invoke Section 80 to take over the matter. It cannot be, my lord. My lord, the court of inquiry normally is, my lord, conducted mostly in disciplinary things. And then, my lord, the other aspect, which is provided by the rules. I'll take to your lordship to that, my lord. Now, my lord, what I am trying to project out here is that the stage of charge sheet has not come. At no point of time they have ever claimed trial. Now, if they are at all aggrieved, my lord, what prevented them from filing an application before the trial court? They have not given any justified reason, my lord. How they anticipate that they will not get any relief there? Now, as of now, my lord, the position is that they have not claimed trial. So, there is no cause of action for them. Because, my lord, petitioner herein is not the accused.
Yes.
My lord, the Union of India. Now, which way Union of India get aggrieved here? It's nothing, my lord. It is custody of individuals, my lord. They do not have locus standi also. One way they say that they have kept them in my lord detention, my lord, they show their intention what that they will prosecute. At the same time, they have come to defend the right of those persons. Those persons are not before a court, my lord. So what kind of approach it is, I do not know, my lord. Now, my lord, lordship may kindly come to my lord the communication dated 9th May 2023, my lord, that is at page 30. My lord, I'd just like to point out the bottom part of paragraph 2 and paragraph 3. But then I will read out the paragraph 2 because I think I'll have to point out other to the lines, my lord.
Yes.
My lord.
My
lord, paragraph 2 and paragraph 3, both the paragraphs I'll
Yes.
be my lord, just placing before lordship, my lord. Now, lordship, I'll use paragraph 2, my lord.
Yes.
It is also to inform you that BSF is an armed force of the Union and our personnel being member of BSF were discharging their official duties in their area of responsibility. As per section 45(1) CRPC, no member of the armed forces of the nation shall be arrested for anything done or purported to be done by him in the discharge of his official duties except with obtaining the consent of the central government. Lordship may pause for a moment, my lord, this protection is given to a member of the armed force, my lord. That member is not before your lordship. So 45(1), there is no question that they can raise. It is further to inform you that section 80 of BSF Act,
there's no qualification as far as member of the armed forces of CAPF or it's not there. So member of armed forces mean armed forces?
My lord.
Not the CAPF.
Definitely not. It is an individual right. Arrest is, my lord, always concerned individual, my lord, right of an individual. My lord. It concerns personal liberty, my lord. So there cannot be two views on that, my lord. No, my lord, I've lost the line. It is further to inform you that the section 80 BSF Act 1960 states that when a criminal court and a security court have each jurisdiction in respect of an offence, it shall be in the discretion of the Director General, of the Inspector General, or the Deputy Inspector General, within those whose command the accused person is serving, or such other officer as may be prescribed, to decide before which court the proceeding shall be instituted, and if that officer decides that there shall be instituted before a special force court, to direct that the accused person shall be detained in force custody. Now, my lord, my lord lordship will think to these things. The institution of a proceeding becomes security force court. Now, security force court has to be in existence. Otherwise, the question of institution will not come. Now, I will take your lordship to the rules just to satisfy whether there exists any security force court or not. Because there are three kinds of security force court, my lord. And only one particular kind will deal with this kind of issues. And the rule says that once a security force court, my lord, conducts and finishes one case, my lord, it gets dissolved automatically. So far as the materials on record, my lord, there is nothing on record to show that a security force court has been instituted. There is not there, my lord. Now, my lord, I'm just proceeding. Now, in this regard, DIG Shillong Quarter BSF, Joy, under whose command HC so-and-so, CT so-and-so, and CT driver so-and-so are serving, has decided in view of Section 80 of BSF Act 1960, read with Section 41 of BSF Rules 1969, that in case any charge sheet is filed, my lord, again there is repetition of before court of law for the trial of above persons. Now, my lord, these words of, my lord, significance, my lord, is the case shall be claimed from the criminal court for trial of accused person by security force court, and has also directed that HC monishing so-and-so and so-and-so to be detained in force custody. Further, as per Section 46 of BSF Act, all civil offences are triable by security force court. Now, my lord, next paragraph are more important, my lord. In this incident, the department has already ordered a court of inquiry which is under progress. As far as investigation in the matter by police is concerned, BSF will provide full assistance to the police for investigation of the case, and IO may record the statement of BSF witnesses as per his convenience, and may also seize the weapon involved in the incident, so if so required. we assure our best cooperation for the artist. My lord, they have given their consent. My lord, this assumes. Now, subsequent to that, my lord, seizure has been made. They have not objected. Now, my lord, what kind of inquiry they will conduct when seized weapon remains with the police? What, my lord, the court of inquiry will do? Now, seizure list has been appended, my lord, in this page 32, my lord. Seizure has been made. Now,
yes,
my lord, the detention is a part of investigation. And if that stage comes, if they are needed to be detained, my lord, section 45(1) would be dealt with by the state police, my lord. But then section 45(1), my lord, has no bearing so far the present institution, present case is concerned, my lord. Now, my lord, coming to law, my learned friend has contended that magistrate concerned had no power to pass the order which has been passed. He said that the court was only, my lord, entitled to pass either order of custody or release, nothing else. Now, had there been an order of custody, my lord, that would have been an interlocutory order. I also agree on that. But then court below has not passed any order of custody. Now, my lord, the order passed, whether that could have been passed or not, my lord, lordship may kindly come to section 81 of BSF Act. Yes, sir. Yes, sir. Power of criminal court to require delivery of offender.
yes.
Subclause 1 says, when a criminal court, may I go, my lord? May I go?
Yes, yes, please.
When a criminal court having jurisdiction is of opinion that proceedings shall be instituted before itself in respect of any alleged offence, it may, by written notice, require the officer referred to in section 80 at his option, either to deliver or to deliver over the offender to the nearest magistrate to be proceeded against according to law, or to postpone proceedings pending a reference to the central government. In every such case, the said officer shall either deliver over the offender in compliance, clause 2 may not be much relevant here, in compliance with the requisition, or shall forthwith refer the question as to the court before which the proceeding are to be instituted for the determination of central government, whose order upon such reference shall be final. Now, my lord, here it seems that the court has a power to require the delivery of offenders. Magistrate concerned, because this is a criminal court, my lord. Now, if at all, my lord, they have any reservation with that, my lord, the court has approached the same court again, and matter could have been referred to for determination of central government, my lord. That has not been done. Now, how it comes here? My lord, there is nothing, my lord, on record to show that the magistrate concerned had no power to pass this order and passed. Now, so far as the correctness is concerned, my lord, that stands a different footing. But then it is not that it is a, my lord, it was a quorum non juris, my lord, it has no jurisdiction to pass that order. Not, my lord, cannot. And the fact remains, my lord, the case has been registered by the police. Now, investigation is going on. They have extended their support there. So, magistrate definitely would have a role to play there. So, it cannot be said, my lord, cannot be said. Now, my lord, so far as the exercise of power under section 80 is concerned, now, my lord, lordship may kindly have a look at section 80, my lord, what it says. And therefore, I take it to your lordship to.
Please.
My lord. Choice between criminal court and security force court. When a criminal court and security force court have each jurisdiction in respect of an offence, it shall be in the discretion of the Director General or the Inspector General or the Deputy Inspector General within whose command the accused person is serving, or such other officer as may be prescribed, to decide before which court the proceeding shall be instituted. And if that officer decides that they shall be instituted before security force courts, to direct that accused person shall be detained in force custody. Now, my lord, there has to be two things, my lord, that there has to be institution before the security force court, if in case they decide, my lord, that it should be taken up by these things, and the force custody comes, my lord, after the institution before the security force court. Material on record doesn't show that there is institution of any matter before the security force court. My lord, it only says, Lordship may kindly come back to the annexures of the writ petition. Lordship will find they have only ordered court of inquiry, my lord. My lord, Lordship may come to page 27, my lord. This is one of the orders.
Page 27. Yes.
Just to show, my lord, whereas a staff court of inquiry has been ordered.
Yes.
Now it speaks about the staff court of inquiry. My lord, doesn't speaks about institution of any proceeding before the security force court. Now what is, my lord, the staff force inquiry, my lord? My lord, I do not know, subject to correction by my learned senior friend, my lord. My lord, so far as my understanding is that a court of inquiry and a staff court of inquiry is same. If there is any, I believe I am correct, my lord. Mr. Shah is there, my lord. So here what has been issued as staff court of inquiry, it should be court of inquiry.
Court of inquiry and staff court of inquiry is same.
Same, my lord. Now, just the provisions. I have written where? 170, 65. This is procedure for civil staff inquiry. My lord, I can take a lordship, my lord, to BSF rules, my lord. My lord, Rule 174, courts of inquiry when to be held.
Yes, please.
Lordship, a court of inquiry may be held to investigate into any disciplinary matter or any other matter of importance. Now, what is any matter of importance, my lord? That is not defined in here, my lord. But then further reading of subclause 2, my lord, may throw some idea about, my lord. In addition to a court of inquiry required to be held under section 62, a court of inquiry shall be held in the following cases. All unnatural death of persons subject to the act or of other persons within the force lines, my lord, these are important. An immediate report shall be sent through the messenger to the officer charged of the police station within whose jurisdiction the place of such unnatural death is concerned. Now, my lord, even in case, my lord, if any incident takes place within their campus, and if it is concerning the subject of the force, my lord, they are also, my lord, they are duty bound to inform the officer in charge, my lord. My lord, number 2, in case when such report cannot for any reason be delivered within a reasonable time, a court of inquiry shall be held into such unnatural death. Now, when law mandates that there should be fast inquiry by the police, then only comes the court of inquiry, my lord, when such report cannot for any reason delivered. Now, number 3, immediately on receipt of information of unnatural death, the commandant of the or the senior most officer of the battalion present shall prepare a report on the performance set down in appendix 13. Now, my lord, where are all those things, if they are at all these things? Now, my lord, interestingly, if lordship comes, my lord, I am saying also not attracted. I am also saying this is not attracted. That is what my assumption is. Oh, sorry. Please. Sorry, I thought you were.
He's telling me.
My lord. Now, what I am trying to, my lord, project is that court of inquiry has nothing, no, my lord, bearing so far as this incident is concerned. It's already been reported to the police and police has taken up the investigation. So rest of the things, my lord, court of inquiry is confined to the disciplinary things only. Which is that? And my lord, more so, just to my lord, the buttress my argument, I'll give a small. What's the judgment of Delhi High Court? How many copies we have? We have extra 3, 4, yeah? Yes. Just to show, my lord, this scope and ambit of the, my lord, what basically, this is Delhi High Court. Small things. My lord, it says that the finding of the court of inquiry is preliminary in nature.
Yes, what is this?
My lord, one second, just, I got mixed up, my lord. You have not marked those paragraphs. My lord, paragraph 8, my lord.
Yes.
Having perused the paper book, this court finds that the respondents have only appointed a court of inquiry under Rule 173 of the Border Security Force Rule 1969. The court of inquiry is nothing more than a fact-finding body. Its findings shall be in the nature of a preliminary report, which will facilitate the BSF in deciding the future course of action. Now, my lord, to my lord say that whether a security force court should take up matter or not, that also they will have to wait for these things. They have not done. So where is the question of, my lord, saying at this stage or revoking section 80 at this stage? It will come only at the stage, my lord, when charge sheet is filed. My lord, therefore, so far as the merit is concerned. But then first thing is that they have to overcome that part, that have the claim trial before the trial court. It is no, admittedly it's not there. They have not filed anything. The order passed, my lord, is a final incurred so far as the handing over is concerned, my lord. So it's a final in nature, my lord. So cannot be said there is the interlocutory order and 397 will not come.
Again, you said, you see, the impute order does not say handing over, is it? It says only for the IO to investigate or to
hand over the custody, my lord. The last paragraph, my lord. In view of the reply submitted by the commandant so-and-so, who has extended his full cooperation into the matter, the court hereby directs the commandant so-and-so to hand over, my lord, the accused person for the purpose of investigation.
See, as you have also submitted, handing over is not necessarily, being incarcerated in custody.
My lord.
Handing over means only for the purpose of questioning them.
That is a preliminary questioning, my lord. If they think that further is needed, if they need custody, my lord, then they will subsequently act according to whatever the law says, my lord.
So it will, you see, it will be dependent on the opinion of the IO, who after questioning them will say that they are required to be, in custody, whether police custody or force custody. That's a different thing.
My lord, it's very much.
This stage has not come.
My lord, definitely no. This stage has not come. And my lord, the whatever way, my lord, it's an interlocutory order or final order, my lord. If it is in interlocutory order, let them go to the trial court if they have any grievance. And if it is final order, my lord, let them file under 397.
The government should also say whether it is, they should have a stand whether it is interlocutory is final.
I said already, that is final so far as the handing over is concerned.
They are not even taking a stand.
I'm taking a stand. I'm saying it, my lord. This is a final
order. You said that.
I'm saying so far as the my lord, a proceeding may have different parts, my lord. Now, which you decide a matter either as interim, interlocutory, or final, my lord. Now, my lord, a certain order, if it has the effect of deciding that issue permanently, my lord, it is a final order. Similarly, it is my lord.
As far as the order directing handing over to the IO is concerned, that's final.
But that is final.
So
There
that's
is
what
final.
you see.
Now, even if my friend says that accounting note is not a final, my lord, then he can go and approach the courts. Bar under 362 will not come. Then this order can be modified like bail custody and all. Police custody, judicial custody, my lord. None of these orders are final orders. Now, my lord,
you're not done.
Pardon, my lord?
You're not done.
My lord, only thing is that, my lord, about the institution of the court, my lord. This is also a direct, I think. My lord, what I am saying that all those documents have been basically prepared in a hush-hush manner or just to protect those accused from being proceeded under the law. Now, my lord, I'll take your lordship, my lord, to section 64 of the BSF Act, my lord, which defines the Security Force Act, my lord. 64, section 64 Act. My lord, the kinds of security force codes, my lord.
Section 64.
Section 64, my lord.
Yes.
For the purpose of this act, there shall be three kinds of security force codes. That is to say, my lord, generally security force code, my lord, general security force code, number 2, petty security force code, and number 3, summary security force code, my lord. Now, my lord, lordship comes to section 68, my lord, the composition of generality security force code, my lord. That is also important, my lord.
Yes.
A general security force code shall consist of not less than 5 officers, each of whom has held the post of Deputy Superintendent of Police for not less than 3 whole years, and of whom not less than 4 are of the rank not below that of a confirmed Deputy Superintendent of Police. The explanation says for the purpose of this section, my lord, of course, this will not be very much relevant. I am just only saying that at least the 5 members who should not be less than the rank of deputy. My lord, where are those? These are not there. Now, my lord, very interestingly, lordship, my lord, comes to section 71, my lord. Now, dissolution of security force code, my lord.
Yes.
Lordship says, if a security force code after the commencement of the trial is reduced below the minimum number of officers required by this act, it shall be dissolved. If on account of the illness of law officer or of the accused before the finding, it is impossible to continue the trial, the security force code shall be dissolved. The officer who commend a security force code may dissolve the same if it appears to him that the exigencies of the service of the necessities of discipline render it permissible or expedient to continue the said security force code. So there are many reasons, my lord, when security force got dissolved. Now, my lord, we do not know whether it is in existence or it is being the stage of dissolved, my lord. Now, my lord, if it says security force code after the commencement of a trial is reduced below, so my lord, commencement of trial.
So there is no standing security force code.
At least, my lord, the materials on record doesn't say so. Their communication doesn't say so.
No, what the act says only, it should be only with regard to particular cases.
Now, my lord, this is, my lordship, I have pointed out there are 3 kinds of security force codes. Now, each, my lord, codes have the powers bestowed in them. Now, so what is section 72, my lord? The powers of general security force code. My lord, a general security force code shall have the power to try any person subject to this act for any offence punishable thereunder and to any sentence authorised thereby. Now, my lord, it has all the power. Now, other codes do not have. Now, my lord, the constitution has to be a general security force code. It cannot be a petty security force code, my lord. My lord, the act itself takes care of the powers of the petty security force code also and the summary security force code. My lord, none of the codes have the power to deal with, my lord, 302 matters.
Three-zero?
302. My lord, this is a murder case, my lord. 302 matters. Section 302 IPC, my lord. I'm sorry, my lord. Now, my lord, now what, my lord, I'm trying to project before this court is that, my lord, this entire petition has been, my lord, designed in such a way so that these people are not available for investigation, those accused. They kindly see, my lord, the petition on Union of India, my lord. My lord, which way it has a cause of action, my lord, to file this case, my lord. Now, my lord, if lordship, my lord, I have taken your lordship to this section 81, my lord, where it says that, my lord, when they are basically not agreeable to the order of production, my lord, better can be referred to the central government. Now, how come if it is there in their court, how Union of India becomes petitioner here, my lord? If the law says that they have the authority to decide the matter, how they come here? Now, this is, my lord, this is Union of India represented by the Deputy Inspector General, my lord. This is the Union of India's party.
But represented by the BSF.
My lord, and it is not that, my lord, they have ever claimed a petition.
Yes, sir.
My lord, I would have remotely imagined their local, my locus standi, had there been an application by them before the court below, my lord. They have not done it. And what is the question of claiming of trial, my lord? These persons may not be this thing, my lord. The law says, my lord, that the basic proposition is that a person is not to be, my lord, regarded as guilty, my lord. He is to be regarded as innocent, my lord. So, anyway, my lord, one way, my lord, they have conveyed their cooperation so far as the investigation is concerned, my lord. That has been projected, my lord. So, they cannot take a diversion, my lord. They cannot, my lord, say that we are cooperating with the investigation, at the same time cause hindrance. So, my lord, there is a petition is no merit, it is liable to be dismissed, my lord. And, my lord, apart from that, my lord, there are other issues with regard to be, my lord, even when, my lord, a section 80 decision is taken, my lord. My lord, the decision of section 80, my lord, the manner or the factors to be considered is guided by Rule 41 of the Act, my lord. Oh, sir, Rule 41 of the rules, my lord. Can be Act, my lord. One, my brain is going.
Rule 41.
Yes. My lord, trial of cases either by security force court or criminal court, my lord. Where, suppose where an offence is triable both by criminal court and security force court, an officer referred to in section 80 may. Now, my lord, section 80 is invoked, my lord, when an offence is triable both the court, by a normal court and by security force court, my lord. He may exercise his power, my lord. Now, the manner is same. It says, part 1 says, where the offence is committed by the accused in the course of performance of his duty as a member of the force, where the offence is committed in relation to property belonging to the government or the force or a person subject to the act.
I think this it will be applicable.
My lord, so far as the my lord, the status of the offender is concerned, my lord, I am not discussing. He is in active service, my lord. So I am definitely, my lord, I will be guided by the law enunciated by Apex Court, my lord. 2013. My lord, I am just relying on a decision, my lord. This will definitely make things more clear, my lord, with regard to the exercise of powers under section 80. You have this? Yeah. My lord, this is 2013 6 SCC, page 333.
Para?
My lord, relevant will be paragraph, my lord, 15 to 19, my lord.
Yes.
Number I'll also rely on that. I have to refer to this. Well, before Lordship, I'll just take it to the relevant paragraphs of these things. Well, I just rely on. I'm making marking here. And my lord, relying on my lord, rule 8 of the Criminal Courts and Court Martial Adjustment of Jurisdiction Rules 1978. I'll just give a copy. Page 2. It's perimeter section 81. My lord, Lordship, come to
what is this?
Page 5. My lord, it starts, my lord, in the middle of the page 2, my lord. Lordship will find number 1. These rules may be called.
Where is page?
Page 2, my lord. On the top, my lord, so page 2 in the middle.
Yes, yes.
Then we will find paragraph number 1, numerical 1, my lord.
Yes.
These rules may be called the Criminal Courts and Court Martial Adjustment of Jurisdiction Rules 1978. And this is the title of the rule.
This is under which act?
My lord, this previous paragraph will say, my lord, in exercise of the powers conferred by subsection 1 of section 475 of the Code of Criminal Procedure, and in suppression of the Criminal Courts and Court Martial Adjustment Rules 1952, the central government hereby makes the following rules for the trial of the person subject to military, naval, or air force law, or any other law relating to armed forces of the Union by a court to which the said code applies, or by a court martial named.
Okay.
Now, my lordship comes to rule 8, my lord. At page 5, my lord.
Yes,
Rule 8, my lord.
Please read.
My lord, notwithstanding anything in the foregoing rules, where it comes to the notice of a magistrate that a person subject to military, naval, or air force law, or any other law relating to the armed forces of the Union for the time being in force, has committed an offence, proceedings in respect of which ought to be instituted before him, and that the presence of such person cannot be procured except through military, naval, or air force authorities, the magistrate may, by a written notice, require the commanding officer of such person either to deliver such person to a magistrate to be named in the said notice for being proceeded against according to law, or to stay the proceedings against such person, magistrate to be named in the said notice for being proceeded against according to law, or to stay the proceedings against such person before the court martial if since instituted, and to make a reference to the central government for determination as to the code before which proceedings should be instituted. Now, my lord, it is in perimeter with section 81. Now, my lord, here, my lord, no proceeding has been initiated before court martial and all. My lord, the security force court as the case may be. But then, so far as the authority power of the magistrate is concerned, my lord, to order for the production of the subject matter, my lord, that is there. So it cannot be said that there is no power. My lord, 9 also, my lord, will be relevant, my lord. Where a person subject to military,
yes, please.
Where a person subject to military, naval, or air force law, or any other law relating to the armed forces of the Union for the time being in force, has committed an offence which, in the opinion of the competent military, naval, or air force authority, as the case may be, ought to be tried by a magistrate in accordance with civil law in force of the in force, or where the central government has, on a reference mentioned in Rule 8, decided the proceedings against such a person should be instituted before a magistrate, the commanding officer, my lord, of course, I'm sorry, my lord, because here central government has not decided. The commanding officer of such person shall, after giving a written notice to the magistrate concerned, deliver such person as proper court to the magistrate. Now, my lord, it comes after the central government decided. Now, my lord, the central government's decision also, it has a bearing here, my lord, direct bearing here. So, here, my lord, central government has not decided anything. Instead, they have come here. Yes. I wanted to project that, now it's not maintainable. Now, my lord, coming to that decision of 2013 6 SCC, my lord, 333. My lord, reading this will make us, my lord, clear the provisions and the rules which way, my lord. Of course, it mostly concerns, my lord, how order under section 80 should be passed. Now, my lord, if my lord, lordship requires that should be deliberated, I will refer to this. But then otherwise, my lord, if my lord on other grounds this matter is decided, then may not be required. But then, my lord, so far as the status of those accused is concerned, my lord, we are not saying that they are not the subject of the armed force, my lord, they are subject. We are not at all disputing, my lord, and we are saying that thing, we are going by the notification of the central government, which has given extended distinct definition of the subject matter. So we are not saying that yes, they are BSF personnel at the time of the commission of the offence also, they are a subject of the force, my lord. But then they have committed offence on non-subject, my lord. Now, in such a case, my lord, the civil courts has a priority, my lord. It is not that if lordship comes to Rule 47, my lord, it says that civil offences, that means, my lord, the offences which is Commander said, not triable by a security force court. Now, my lord, of course, thereafter, my lord, it lays down the my lord, may I read it?
Yes.
47. A person subject to this act.
You're reading?
Rule 47, my lord. Section 47 of the act. Sorry, my lord. Section 47 of the act. I'm sorry, my lord. I'm becoming too old, my lord. It's okay. I'll read from here. It's there.
Yes, please read.
My lord, it says, a person subject to this act who commits an offence of murder or of culpable homicide not amounting to murder against or of rape in relation to a person not subject to this act shall not be deemed to be guilty of an offence against this act and shall not be tried by security force courts unless he commits any of the said offence while on active duty at any particular place outside India, at any place specified in the central government by notification on this behalf. Now, my lord, they have taken shelter of all those things, my lord, the last part of the ABC, my lord. Otherwise, my lord, in normal cases, my lord, if there is any offence committed against a non-subject of the act, my lord, it should be tried by these things. Now, my lord, exemption is, my lord, when he falls under any of these three categories, my lord, ABC. So it is presumed that cannot be said that the normal court doesn't have any jurisdiction to try it, or the security force court has any primacy over the subject matter.
Look at the wordings here. It says, and shall not be tried by a security force court.
Oh, yes, my lord. That means therefore. It means should be tried by a civil court.
Should be tried.
Now, my lord, lordship, reading section 15 onwards, my lord, will make things more clear.
Section
15 onwards.
Yes.
Sorry, my lord, paragraph 15. Well, paragraph 15 of the judgment. I'm sorry, my lord. I'm extremely sorry, my lord. What happened? My lord, 2013 judgment.
Yes, please.
My lord, basically it's a new subject for me, my lord. My lord, I also took time to, my lord, read and understand, my lord. My runner friend is definitely habituated handling those acts, my lord. I am not. My lord, 15 says, as we have found that the accused persons have committed the offence while on active duty within the extended meaning, the bar under section 47 of the act shall not stand in their way for a trial by a security force court. The bar of trial by a security force court, though is lifted, but the bar of trial by a security force, though is lifted, but it does not mean that the accused who had committed the offence of the nature indicated in 47 of the Act shall necessarily have to be tried by a security force court. In a given case, there may not be a bar of trial by a security force court, but still an accused can be tried by a criminal court. In other words, in such a situation, the choice of trial is between the criminal court and the security force court. The situation is visualized under section 80 of the Act, which reads as follows. Now, my lord, we have gone through it. I am not bothering lordships. As we have the section para 16, my lord. As we have observed above, the present case, the criminal court and the security force court each have jurisdiction for trial of offence which the accused persons are alleged to have committed. In such a contingency, section 80 of the Act has conferred discretion on the Director General or the Inspector General or the Deputy Inspector General of the force within whose command the accused person is serving to decide before which court the proceeding shall be instituted. Section 141 of the Act confers powers on central government to make the rules for the purpose of carrying into the effect the provisions of the Act. It is relevant here to state that the central government, in exercise of powers under section 41(1) and 2 of the Act, has made the Border Security Force Rules 1916, chapter so and so is in relation to the choice of the jurisdiction between security force court and criminal courts. Thus, for exercise of discretion under section 80 of the Act, rules have been framed, and Rule 41 of the rules, which is relevant for the purpose, reads as follows. The trial of cases either by security force court or criminal court. Where an offence is triable both by criminal court and a security force court, an offence referred to in section 80 may, where the offence is committed by the accused in the course of his performance of the duty as a member of the force, or where the offence is committed in relation to property belonging to the government or the force of a person subject to the Act, or where the offence is committed against a person subject to the Act, direct that any person subject to the Act who is alleged to have committed such an offence be tried by a court. My lord, court will mean a court of ordinary jurisdiction. Court will mean a security force court. My lord, this is defined in section 2, rule 2 of the things. And if any other case decide whether or not it would be necessary in interest discipline to, my lord, kindly take these words, my lord, to claim trial by a court.
Yes.
Any person subject to the Act who is alleged to have committed such an offence. Now, Lordship, my lord, subclause 2 says, in taking a decision to claim an offence for trial by the court, my lord. So, where is the claim by them, my lord? An officer referred to in section 80 may take into account all or any of the following factors. The offender is on active duty or has been warned for active duty and it is felt that he is trying to avert such duty. The offender is a young person undergoing training and the offender is not serious one, and the trial of the offender by criminal court would materially affect his training. Number 3, the offender can, in view of nature of the case, be dealt with summarily under this Act. Now, my lord, I am not much on those aspects because I have already considered that is a subject matter of the Act, my lord. Yes. Only thing is that, my lord, the claiming, which I try to point out, that to claim trial. One rules makes it clear. To claim trial. We have not reached that stage. Now, my lord, comes to section paragraph 18, my lord. Rule 2C of the rule defines court to mean the security force court. A bare reading of Rule 41(1) makes it evident that where the offence is committed in the course of performance of duty as a member of the force, or where the offence is committed in relation to property belonging to the government or the force or a person subject to the Act, or where the offence is committed against a person subject to the Act, the officer competent to exercise the power under section 80 of the Act may direct that the members of the force who have committed the offence be tried by a security force court. The allegations in the present case do not indicate that the accused committed an offence in course of performance of their duty as a member of the force or in relation to property belonging to the government or the force or a person subject to the Act, or the offences was committed against a person subject to the Act. In that view of the matter, the aforesaid ingredients are not satisfied and therefore the jurisdictional fact necessary for trial of the accused person by a security force court does not exist, my lord. I'll just stop for a moment, my lord. Here, my lord, the incident had occurred in a place which was 17.5 kilometers far from the border, international border. Now, my lord, this fact has to be considered, my lord. The subject matter, the victim is not a subject to the Act, my lord. Now, my lord, nothing has been discussed so far as their exercise of power section 80 is concerned, my lord. they have not taken into provisions of the rules. So this is basically, it will not stand in the eye of law, my lord. Now, my lord, paragraph 19, my lord. The last paragraph 19, my lord.
Yes.
Rule 41(1) further authorizes the officer competent to exercise the power under section 80 of the Act to decide as to whether or not it would be necessary to, in the interest of discipline, to claim the trial by a security force court. It is worth mentioning here that Rule 41(2) enumerates the factors which the officer competent under section 80 of the Act is to take into account for taking a decision for trial of an accused by a security force court. None of these clauses of section 41(1) subclause I and 41(2) apply in the facts of the present case. The conditions under which the authority would exercise the discretion is provided under section 41(1)(2) of the rules. Now, similarly in this case also, my lord, nothing has been done. So, my lord, I just sum up by saying that, my lord, this petition cannot be entertained, my lord. It should be dismissed, my lord. It has no merit. It's not maintainable. It should be dismissed in the name.
My lord, so many issues have been raised, my lord. I have to rebut one by one, my lord. Should we resume after lunch? Your lordship pleases nap tomorrow also.
You're not willing after lunch?
I'm okay. I can. Because so many points.
I have no problem. I'm open for ending.
After lunch?
Yes, after lunch. At 2:15?
2:15, my lord. My lord, I'm sorry for my lord. It gets overlapped, my lord. I sometimes. मैं कुछ गलत नहीं कहा
Please.
Also, the first of the ground raised by the respondents, my lord, is that the present petition is filed by Union of India, my lord, through the BSF, and not by the accused persons. So, Union of India has no locus standi to file the present petition, my lord. My lord, in this regard, as your lordship has seen, the issue here is the jurisdiction as to which court will try the offence, whether BSF court or the Sessions Court, my lord. Now, I'll just refer to the Sikkim decision, my lord.
Yes.
My lord, the lordship kindly comes to internal page 315, my lord. Para 38 starts from the previous page, my lord. Para 38. The lordship turns over to next page, my lord. Another decision of Supreme Court in Balbir Singh's case has been quoted, my lord, here.
Yes.
I'll just read 2-3 sentences in the last.
Yes.
In the quoted paragraph, my lord, which is in the italics, my lord.
Okay.
It is explicit that the option to try the accused subject, lordship has got it. First quoted paragraph, my lord, last 3 sentences.
Yes.
It is explicit that the option to try the accused subject to that by court-martial is with the Air Force authorities, and the accused person has no option or right to claim trial by a particular forum. Well, the accused person has no option.
Yes.
The option is to be exercised by the BSF authorities in this case, my lord. So the aggrieved person, in fact, in reality, is the BSF authorities, not the accused persons, my lord. Because accused persons have no right to be tried by a particular forum, my lord. So this argument that those accused persons should have come before this honorable court and not BSF authorities, my lord, in my humble submission, is not a correct submission, my lord. My lord, the second submission will be that, my lord, kindly sees the wordings of section 80 and 81 of the BSF Act, my lord.
Yes.
I'll just emphasize few words, my lord, here. When a criminal court and security force court have each jurisdiction in respect of an offence, it shall be in the discretion of the Director General or the Inspector General or the Deputy Inspector General within whose command the accused person is serving, or such other officer as may be prescribed, to decide before which court the proceedings shall be instituted. My lord, the catchphrase here is proceedings shall be instituted, my lord. And if that officer decides that they shall be instituted before a security force court to direct that the accused person shall be detained in force custody.
You are reading?
Section 80, my lord, of the BSF Act.
80?
80.
Yes.
My lord, the words used are institution of proceedings, my lord. Proceedings shall be instituted. Now the question is at what stage section 80 and section 81 will come into picture, my lord.
Yes.
Because it appears that the respondents are relying on section 81, which talks about magistrate's power to direct for handing over the offender, my lord. Now section 80 and 81, my lord, I'll draw support from 2 decisions of the Supreme Court, is that section 80 and 81 will come into picture only after filing of the charge sheet, my lord. Section 81 especially. the power of section 81 is the power of the magistrate, okay, power of the criminal court to require delivery of offender, which says that, my lord, when a criminal court having jurisdiction is of the opinion that proceedings shall be instituted before itself in respect of any alleged offence, it may by written notice require the officer referred to in section 88 his option either to deliver over the offender to the nearest magistrate to be proceeded against according to law or to postpone proceedings pending a reference to the central government. So once a charge sheet is filed, my lord, what is the purport of section 81? After the charge sheet is filed, and magistrate finds that the offence may also be triable by a security force court. What are the choice before the magistrate, my lord? Is that the magistrate will issue a written notice to the commandant to hand over the custody of the offender, to whom, my lord, will kindly notice that part, my lord, to the magistrate, my lord. Nowhere it says that hand over the custody of the offender to police, my lord. Your lordship will kindly noted that those words, my lord.
Yes.
So section 81 will come into picture only after filing of charge sheet, my lord. And this, your lordship will find in the same decision, my lord, in para 39.
Yes.
Para 39, my lord. It refers to another decision of the Supreme Court. Then it says, my lord, the court in Army headquarters then recorded its conclusion in para 95 of the report, and they read as follows. To sum up, the conjoint reading of the relevant statutory provisions and rules make it clear that the term institution contained in section 7 of the 1990 Act means taking cognizance of the offence and not mere presentation of the charge sheet by the investigating agency. The competent arm authority has to exercise its discretion to opt as to whether the trial could be by a court martial or criminal court after filing of the charge sheet and not after the cognizance of the offence is taken by the court. Facts of this case require sanction of the central government to proceed with criminal prosecution. So basically, the institution of proceedings, my lord, is a stage when charge sheet has been filed, but cognizance has not been taken by the magistrate. Before taking cognizance, the magistrate will have to issue. So only at that stage, after charge sheet has been filed, the magistrate can order for handing over position of the accused. That stage has not even reached. We are in the stage of investigation now, my lord. So the reference that the magistrate has exercised power under section 81 of the BSF Act, in my humble submission, is absolutely without jurisdiction, my lord, because that power will be available to magistrate only after the charge sheet is filed, my lord. My lord, in the same decision, again, para 29, my lord.
Yes.
My lord, para 29 on the next page, my lord.
Yes.
After about 12 lines, my lord, the italics portion, my lord, on the next page.
Yes.
It is manifest that Rule 3 only applies to a case where the police has completed investigation.
Yes.
And the accused is brought before the magistrate after submission of a charge sheet. The provisions of this rule cannot be invoked in a case where the police has merely started investigation against a person subject to military, naval or air force law. So, my lord, section 80, 81 and rules, adjustment of jurisdiction rules, my lord, those are the rules framed up to facilitate how section 80 and 81 are to be exercised, my lord. So all these rules, my lord, rules 3 to 9 and section 80 and 81, section 81 especially, will come into picture only after filing of the charge sheet. We have not even reached that stage. We are in the stage of investigation, my lord. Again, my lord, section 81, I'll read once again, my lord.
Yes.
It says, my lord, power of criminal court to require delivery of offender. When a criminal court having jurisdiction is of opinion that proceedings shall be instituted before itself in respect of any alleged offence, it may by written notice require the officer referred to in section 80. So in our case will be IG, DIG or BSF, my lord, at his option of the IG or DIG, my lord. Magistrate cannot even force even in exercise of power under section 81 also, my lord. Magistrate can only issue a notice saying that the magistrate proposes to conduct the trial of this case. In that case, he has to issue a notice to the DIG or IG, who at his option, my lord.
Yes.
Then it says, either to deliver over the offender to the nearest magistrate to be proceeded against according to law, or to postpone the proceedings pending a reference to the central government. Then second part says, my lord, in every such case, the said officer shall either deliver over the offender in compliance with the requisition, or shall forthwith refer the question as to the court before which the proceedings are to be instituted for the determination of the central government, whose order upon such reference shall be final. My lord, magistrate has no adjudicatory role in this, my lord. Magistrate can only request the commandant, but if commandant exercises power, the DIG, my lord, DIG or IG, the magistrate has to simply postpone the proceedings till the decision by the central government, my lord. My lord, I hope I am clear on that.
Yes, yes.
So, my lord, to say that the magistrate has passed this order, the present order under section 81.
But who's to initiate the process, for the decision of the central government to be?
My lord, it says, my lord. My lord, so section 2 says, my lord. So magistrate will issue a written notice, my lord, giving two options: either you hand over the custody of the accused, or second is to postpone proceedings pending reference to the central government. Section 2 says, my lord, in every such case, the said officer, he has two choices, my lord, either deliver over the offender in compliance with the requisition, first part, my lord, or shall forthwith refer the question as to the court before which the proceedings are to be instituted for the determination of the central government, whose order upon. So when a notice comes, my lord, the DIG or IG has two choices, my lord. If he says that no, we don't want the BSF to try it, hand over the accused, my lord. If he opts otherwise, my lord, then what he'll do, he'll immediately refer the matter to central government, my lord, and the decision of the central government in such matter is final. So, my lord, we have not reached that stage. That is why I'm trying to submit, my lord, that we have not reached the stage of section 80, 81. So, to make a submission, my lord, in that the magistrate has passed this order under section 81 of the BSF Act is not correct. As I submitted, my lord, the magistrate at this stage has no power to direct. The order passed by the learned magistrate is absolutely without jurisdiction, my lord. Also, my lord, the next point is my lord, section 47 of the BSF Act, my lord.
Yes.
It says, my lord, of civil offences not triable by a security force court. My lord, may I point out one thing here, my lord, because this is causing a little bit of confusion. Civil court and criminal. The civil court normally we mean.
Civil court would mean civil authorities or
the courts of session judge in this present context, my lord. It says civil offences not triable by a security force court. A person subject to this act who commits an offence of murder or of culpable homicide not amounting to murder against or of rape in relation to a person not subject to this act shall not be deemed to be guilty of an offence against this act and shall not be tried by a security force court unless he commits any of the said offences while on active duty at any place outside India, at any place specified by the central government by notification in this behalf.
Yes.
Here we are covered under exception A, my lord, that the duty was performed while on active duty. So the BSF court has the jurisdiction and competence to try the offence. As far as punishments, my lord, section 48, my lord, so kindly has a look, my lord.
Yes.
To cast some kind of aspersion on the abilities of BSF court, my lord, it is very unfortunate on the part of the state government, my lord. I have been told that BSF courts complete their trial within a time frame of 9 months, my lord, and they have awarded several death sentences, my lord, till now, and in hundreds life imprisonment, my lord. So to say, my lord, this I am nobody to. They are thinking that state government or the are more competent, but I am not laying that kind of claim, my lord. But the law says, my lord, that in which case BSF court will try the cases and which case session courts will try the case. That is for the parliament to decide which is more effective. But to say that we will be lenient to our BSF personnel, my lord, that is absolutely unfounded. In fact, the BSF courts, what I find, my lord, are more severe, my lord. In fact, what I have been told that in normal court, if charge sheet is not filed within 90 days, they get bail, my lord. In BSF custody, there is no question of bail, my lord. They conclude the trial, and after punishment is awarded, then only whichever way the sentence goes, my lord, they face that, my lord. My lord, the punishments that can be awarded by security force court include death sentence, my lord.
Yes.
So, my lord, why this idea, my lord? Why jurisdiction is given to security force court? My lord, I submitted on the day of motion also, my lord. There are several offences which are not offences under the Indian Penal Code, my lord. Sessions court can only try IPC offences, my lord. They have no jurisdiction to try BSF offences. Under Army Act, my lord, not obeying the command of a superior officer is a criminal offence, my lord. They can be punished for that, my lord, including sentencing. There are several such not following the protocol. Even I've been told that in this case, maybe this is still under investigation. The accused people, they offended the SOP, standard operating procedure, how smuggling vehicle has to be detected or how it has to be stopped, my lord, which are not an offence under the Indian Penal Code, my lord. The session court will only try him for 302, nothing else, my lord. But depending on the investigation, we will try him for many more things, my lord. Apart from 302, many other sections may come into picture, my lord. So, my lord, so as I submitted, my lord, the offence being committed while on active duty, my lord, the BSF court has the competence, my lord. Now, the again question on maintainability, my lord, that this is an interlocutory order, this is a final order, my lord, and so a revision is applicable before the session court, my lord. And respondents are not taking a definitive stance. Sometimes they are saying that it is a final order, so you go to session court. And if I feel that it is an interlocutory order, I should go to same magistrate, my lord. The bar of 362 will not apply in case of interlocutory order, my lord. But in my humble submission, I placed a decision of, on the last occasion, 2004, volume 5. I think it is there on the file, my lord.
Not here. Yes.
2004, volume 5, my lord.
Yes. Para
13, my lord.
13.
13.
38.
Magistrate, 13, 1 3.
Yes.
May I read, my lord? Section 167 CRPC empowers a judicial magistrate to authorize the detention of an accused in the custody of police. Section 209 CRPC confers power upon a magistrate to remand an accused to custody until the case has been committed to the court of session and also until the conclusion of the trial. Section 309 CRPC confers power upon a court to remand an accused to custody after taking cognizance of an offence or during commencement of trial when it finds it necessary to adjourn the inquiry trial. The order of remand has no bearing on the proceedings of the trial itself, nor can it have any effect on the ultimate decision of the case. If an order of remand is found to be illegal, it cannot result in acquittal of the accused or in termination of the proceeding. A remand order cannot affect the progress of the trial or its decision in any manner. Therefore, applying the test laid down in Madhulime case, it cannot be categorized even as an intermediate order. The order is therefore a pure and simple interlocutory order, and view of the bar created by subsection 2 of section 397 CRPC, a revision against the said order is not maintainable. The High Court therefore erred in entertaining the revision against the order dated so and so of the Metropolitan Magistrate granting police custody of the accused Joy Immaculate for 1 day. My lord, our case, the learned magistrate has directed to hand over the offender to the IO, my lord. I was trying to locate an exact case, but it appears that that is a very unique case, my lord, that the order impugned here. It appears that no such order, at least there is no reported case by High Court or Supreme Court. I don't think such matter will reach, my lord. So this is more or less in the nature of. What is the definition?
Even if you, perhaps I may be wrong, if you interpret the order, it would simply mean that the magistrate has directed
to hand over the
accused. The accused to be questioned by the IO. Handing over to IO means what? It's not for the sake of custody.
My lord, if it was simply for questioning, my lord, we have no issues, my lord. We can accompany the accused person to them, or they can come wherever he is detained, my lord. They can record the statement.
So what is the role of the IO? The role of the IO is to investigate into matter, and in the process of investigation, he questions relevant witnesses. He goes to the site, PO, and so on and so forth. That is it. So he is in no position to be in charge of the custody of the accused. It is only on the basis of the court's order that the accused can be remanded to police custody or judicial custody, whatever. So here in this, open to interpretation, because the court may not have framed the wording.
This order was passed without even giving us a chance to hear, my lord. If some kind of notice was issued to us, we could have at least apprised the learned magistrate also that these are the provisions, at least to please take care of these aspects also. This is an order without hearing, without any notice to us, my lord. And if your lordship clarifies that aspect, we are okay with that. We have no problem.
Yes, Mr. Bharsati, what do you say to that?
Because, my lord, I may just add.
What do you say to that? Let's say interpretation. Of course, this court is not in a position to impute meaning, but from the face of it, the impute order would suggest that the magistrate has allowed or rather has called upon the Army Authority or the BSF Authority to allow the IO to, question them. See, but handing over, I think it's just a word use, maybe misplaced.
Yes. Well, that will handing over. What does it mean? It doesn't mean permanent handing over, my lord.
Exactly.
Now, my lord, so far as the detention is concerned, my lord, that is solely prerogative of police.
What you said is correct.
Now, whether it is not required or is not required, that will be decided by the police. And if they think, my lord, that custody is needed, then they will have to comply with the section 45(1), my lord. That is a must. It is not that this order will basically negate the provisions of 45(1), my lord.
So you see, let's forget about the technicalities. See, forget about the technicalities. Let's put it this way. If the import of the order is such that they are required for questioning, and you are willing to hand them over for questioning to the IO, under protection or whatever, and take back the custody with you, that would suffice.
We have no problem
for all intent and purposes as far as the investigation is concerned.
No, my lord, whether custody will be required or not,
that will come later. You see, if after questioning, the IO is of the view that they are required to be remanded to custody, then perhaps there will a procedure would follow for which the BSF would be put to notice, and all these subsequent
permission has to be.
So all the subsequent procedure will follow. I think to that extent, I think the matter can be resolved.
To that extent, in fact, we have called them police. Please come and interrogate. We have no problem with that.
Why police should go to them? Police, will they decide in which place they have to be interrogated?
Whatever. Let's
we'll take them to
let's put it this way.
Station,
even if if it is required in the police station, they will come and bring them. Bring them to the interrogation room.
Yes,
and bring them, take it back.
There's no problem with that.
Interrogation is part of investigation, my lord. Which manner it should be done, where it should be done, it is a prerogative of the investigation.
So now it's for the IO to decide.
Definitely, my lord. So we are not basically embarking up we are not entering.
Yes, we are not. Exactly.
We cannot, my lord.
But what we say is, we see what we say is this: we give a free hand to the IO to conduct its investigation.
Definitely, it has to.
And in that process, you see, if the BSF authority, in fact, as it is, it appears that they are willing to cooperate and are cooperating. So now it will be incumbent upon the BSF authority and the IO, the communication between them, as to in what manner the questioning or interrogation will take place. To that extent, I think the whole issue will be
only
resolved.
clarification, my lord, that's imminent, my lord. If IO wants to arrest, then he must
Yes,
comply.
that will be a different procedure.
That is a mandate of law, my lord.
Yes,
it goes without saying,
yes,
my lord.
it goes without saying.
My lord, basically, to my lord, so far as we are concerned, my lord, to say that there has to be a negotiation for interrogation.
No, that is not for us.
We will be embarking in the arena of.
No, we are not.
Now,
that is for the IO to decide.
Their communication explicitly shows that they said they will extend fullest cooperation so far as investigation is concerned. And my lord, that becomes the reason for the magistrate to pass an order, my lord. Because the magistrate has to give some reason, and that becomes a reason. Now, can they say that they will extend partial investigation? That cannot. Either they say, once they say that they will extend cooperation, then my lord, the interrogation or custody, my lord, this becomes part of this investigation.
Now,
kindly, I have not finished. My lord, if during the course of the investigation, is custody is needed, my lord, then naturally 45(1) will come into place.
Exactly.
So where is the fear in that, my lord? Is it their purpose to protect the thing from the arrest? I don't think Union of India can come with that plea, my lord.
No, I don't
because that is an individual right.
It's not in their. I don't. It has not occurred to them also.
Repeatedly, they are harping on that issue.
Casting as person again, my lord. My lord, I pointed out two decisions right at the beginning, my lord, because the Supreme Court has held that if you hand over the custody of the accused person to civil police, my lord, that amounts to surrendering the jurisdiction, my lord.
See, now we have,
that is why we have come.
We have gone to the provisions, the Act and the rules, which predetermine a set process as far as handing over custody to the criminal court or the IO for that matter. It would be only after the charge has been filed. Before that, it is open for the IO to conduct its investigation in whatever way it chooses. And that would there is nothing in the Act which says that the BSF can prevent that, or the authorities can prevent it. So, if we are agreed on that,
in that case, a sort of
then we allow the IO to continue its investigation, and for the IO to since you see it's a peculiar case where now they are in the custody of the authorities or the BSF for that. So it is for him to go and talk to them or discuss with whoever is in charge. And then that can be if he say you bring them over to the.
That is for IO to.
Yes. So if he says that is for the IOC, and you say yes, I'll come, it's up to him.
Definitely, and without consulting the commanding officer, he will not, because he is there in custody. So
that's what I said.
So that is for him to negotiate which manner he negotiates, my lord.
The place of interrogation on what kind of cooperation is required, we are open to that, my lord. It is not an intention to want to hide or conceal anything, my lord. Our only apprehension, my lord.
I understand.
My lord.
Is only
we don't want to surrender the jurisdiction.
It's only with. So what do we do?
My lord, in that case, if it's agreed, my lord, a very short order can pass without going into all the niceties of law, my lord.
Well,
If that order is clarified to that
we
extent.
should not have the problem with if that order is passed, but then they should be made available, my lord. That should not, my lord. BSF should not hide them.
No, that he's already I'll record that
I'm
in
very
the order.
candidly submitting that one.
I'll record that in the order.
So there's absolutely no problem. We will, if they want in their police station, my lord, we will escort them. We'll bring him back. Whatever other cooperation he requires, but he wants to arrest, he'll comply with section 45. Only that much clarification is given, my lord. At least IO will understand. Otherwise, he'll do something unnecessarily.
So we'll dispose of this matter in that line.
My lord, though my lord, I still have reservation about lordship exercise jurisdiction under 482.
But
It's okay, but my learned friend said that the state has not taken a stand. No, my lord, they have come to the court.
Now, once
They
the matter
should,
is resolved,
they should take a stand. It is not for me.
Matter is resolved now, so I don't think we should.
So submission has been advanced by saying that, my lord, we have not taken a stand. It is not for us to take a stand.
I finally, like I said again, finally it's just a question of misplaced wordings.
Only, my lord.
The magistrate,
instead of that, handed over, some other word was used.
The magistrate, in all earnestness, has thought it fit to allow the IO to continue the investigation, interrogation, or questioning. But the word handing over has irked you.
My lord, even lordship will find, my learned friend has read on the Sikkim case. Now, Sikkim case also, my lord, they were handed over to police. Both were subject of the BSF, my lord, of the armed forces.
Before
that is why Supreme Court said that once you have handed over, that means you have surrendered your jurisdiction.
Lordship will find the Jammu and Kashmir case also, my lord. Lordship will find that the accused were handed over to police. So
that is why we have become more wise, my lord, now after those after setbacks from Supreme Court, my lord.
That is never been evident, my lord, because normally, my lord, the incident has occurred outside the area. The subject of, my lord, the victim is not a subject.
BSF has jurisdiction in the entire state of Meghalaya.
So no way they can say that the police has no right to investigate, or their investigation would be hampered.
But I think finally it is incumbent, of course, on all authorities and in the state to see that justice, is
justice is done, my lord. Absolutely, my lord.
To that extent, you see how you do it.
My lord.
It's
there's nothing, my lord.
Will be a subject matter later on.
Perception that is I don't know on what is the basis that BSF court will be lenient to its people. My
lord. It is not that, my lord. It is not that. It is not that, my lord. We are arguing a case, my lord. And my lord, we definitely argue by taking many points. I have never said that BSF will be lineal, BSF will not be punishing them. It's not that. My lord, I only said that two things. One way, my lord, they order their detention. At the same time, there is nothing on record so that even that security force code is in this thing, my lord. Here, my lord, what happens? The order is passed for handing over the custody of these things. Now, union runs, my lord. The accused should have come. Accused does not come.
Accused has no right, my lord. I pointed out the accused has no right.
If at all, my lord.
My lord, I think it's resolved now. We'll leave all these arguments for some other case, my lord.
And my lord, the main thing is that why it has not been referred to central government, my lord. It should have been done immediately.
No, that will come, I think, in due course.
That will come after section 81, my lord.
Section 80.
After charge sheet is filed with police.
Challenge has been made to the order dated 15/5/2023, passed by the learned Magistrate First Class Shillong in connection with Punusla PS case number 12/5 of 2023 under section 120B/302/201 IPC. Should be read with section 27 Arms Act. from the petition. What is seen is that the background of this matter relates to an alleged incident which relate to an incident which had taken place on, when was the date? When did it happen?
5/23.
Oh, 5/5/2023. On the Penursla Dauki Road near Wakdaj village, in which 3 BSF personnel apparently deployed for duty happened to locate, or rather meet, a vehicle which was traveling in a suspicious manner, and according to the said personnel was suspected of carrying contraband goods or livestock. On the said vehicle being asked to stop, and on the driver of the said vehicle failing to heed to the request, it is said that the said personnel had taken the step to try and stop the fleeing vehicle by shooting upon the said vehicle. As a result, one person was rendered injured and who subsequently succumbed to his injury. Next. The procedure of law which followed demands that the said alleged offenders who are BSF personnel were taken into custody by the BSF authorities. In the meantime, on an FIR file, the said Punusla PS case number so was registered, and investigation commenced. In course of investigation, the matter was brought to the attention of the learned magistrate, who as mentioned above by the order dated 15/5/2023 impugned herein, had inter alia directed the Commandant 4th BN BSF to hand over the accused person and a bracket BSF personnel, the 3 BSF personnel to the investigating officer for the purpose of investigation. Next, the petitioner, Public Union of India, being aggrieved by this order, by the impugned order, had accordingly approached this court with a prayer to set aside and quash the said order. Next, the state respondent has resisted this petition and has consistently submitted that there is nothing wrong with the impugned order and the manner in which it was passed, and as such the learned magistrate has not committed any error of jurisdiction or otherwise. Upon hearing Dr. N. Musica, learned CG DGSI for the Petitioner Union of India, and Mr. B. Bhattacharjee, learned AAG for the state respondent, and without the parties pressing for a resolution in their favor, this court has thought it fit not to go into the details of the argument in advance, but on a somewhat conciliatory mode as expressed by the party, has deemed it fit to dispose of this petition as follows. That the authorities, BSF authorities, shall cooperate with the investigation of the matter and shall accord all necessary cooperation to the investigating officer in course of his investigation. To this extent, the BSF authorities are at liberty to make it convenient for the alleged accused and a bracket BSF personnel to be questioned by the IO as per his convenience. The IO would function within the parameters of said procedure, and any further requirement beyond that would require him to take steps as per procedure set down or laid down in the relevant laws, particularly under the BSF Border Security Force Act 1968 and the rules thereof, as well as under the Code of Civil or Criminal Procedure. The impugn order, to this extent, is not interfered in any manner. In view of the above, this petition is hereby disposed of. Is that okay, or would you want anything else?
My lord, only that's Section 45 is mentioned, my lord. Other than that,
in accordance with law, it is there, my lord. Why
it will create confusion, my lord.
No, because you see, like I said, we will leave it for the IO to use his wisdom and discretion if it is required. Like I said, as far as I could envisage, it appears that the IO is not in conflict with the BSF authorities and vice versa. So in that case, you see, whatever mode or manner that is required to be followed, like I have pointed out, according to provision of BSF Act or CRPC, it will be done. If the time comes for implementation of the Section 45, it will be done. The only thing is that it has to be done in proper accordance with the procedure.
My lord, on ground, what happens, my lord? Here, Mr. Bhattacharya, we understand, my lord, but we will not be because how the police or the IO will interpret this order, how BSF authorities will interpret this order, my lord. Then again, we have to send opinion. Mr. AG has to give. Only that much is clarified that Section 45 will. In case of a further arrest is required, Section 45 will.
If Section 45 is to be mentioned, then all the other corresponding section has to be Section 80, 81. All those things have to be mentioned then.
Well, Section 45 already stands in their advantage so far as the BSF personnel is concerned, my lord. So nobody can go and arbitrarily arrest somebody. If any IO wants to go and arrest them, my lord, then naturally, my lord, the authority will first ask for sanction. So
yes.
If it is not there, how the arrest will not cannot execute.
If arrest is to be required, then
the first thing the IO will
sanction
do,
of the central government is required.
That is what.
My lord, only that much observation it could come, my lord. This will solve the problem, my lord, at least for BSF.
Let us read again 45. What does it say?
And it's only protection from arrest by the police without sanction. 45(1). But then again, my lord, 45(1), my lord, as I say, my lord, it concerns the individual, my lord. It concerns individual, my lord.
But here it talks about one who abets.
Yes, my lord.
Not the one who commits.
No, my lord. It says, my lord, Section 45.
Both, it takes up.
Notwithstanding anything contained in Section 41 to 42, both inclusive. No member of the
Section 45, isn't it?
45, my lord. CRPC, my lord.
Yes. Or CRPC. Sorry.
Probably, my lord, the virus has spread from my side.
Dangerous. Yes, notwithstanding
anything contained in Section 41 to 40, both inclusive, no member of the armed forces of the Union shall be arrested for anything done or purported to be done by him in the discharge of official duties, except after obtaining the consent of the central government.
The law is very much clear, my lord. What is needed more?
So, I go in the paragraph, Sure Lord. As the learned DSGI has laid stress on the fact that the IO may be reminded that in the course of an investigation, the provision of Section 45 is required to be complied with as and when necessary.
That'll do, my lord. 45 CRPC, my lord.
CRPC. That depends on the let the IO take
as and when necessary, my lord. That is
as and when
my learned friends was in front.
We could have reached there right in the beginning.
That's why you have to read and interpret. The only thing is that I'm afraid that whether the High Court can impute meaning, to an order. It can interpret.
When there's no clarity, Lordship can clarify the order.
Thank you.
Deeply.